Hi, everyone. I'm Mike Rappaport, Director of the Center for the Study of Constitutional Originalism, and I'd like to welcome everyone to San Diego and to USD for the 11th Annual Hugh and Hazel Darling Foundation Originalism Works in Progress Conference. It's great to see everyone here at the conference, people who've been here virtually every year, people who've attended just a few times, and some newcomers. Over the years, the conference has helped promote, I think, a community of originalist scholars, which includes proponents of originalism, critics of originalism, and simply those interested in originalism. We thank you so much for your contributions to the conference and to this community, which we hope continue to thrive in the future. Now, every year at the beginning of the conference, I use this time to review some of the important events concerning originalism in the past year. This year, for the first time in many years, the most significant event has not involved a Supreme Court vacancy or appointment, such as Justice Scalia's passing, Justice Gorsuch's nomination and appointment, or Justice Kavanaugh's appointment. In fact, if any appointments in the past year have been significant events for originalism, it's been the large number of circuit court judges who President Trump has appointed. Among the nearly 1/3 of all circuit court judges that Trump has appointed during his presidency, many of them are originalists. As for the Supreme Court, with 2 or 3 strong originalists on the court, one might have expected that the court would have decided a significant originalist case. Another DC versus Heller, if you will. But that has not happened. In Gamble versus the United States, the court did consider whether the original meaning allowing for the dual sovereignty doctrine of the double jeopardy clause, but only one of the originalist justices believed that the original meaning evidence sufficiently supported eliminating that doctrine. The closest case to an originalist blockbuster was Gundy versus the United States, where Justice Gorsuch's dissent, joined by 2 other justices, made an originalist case for a strong non-delegation doctrine. But Gorsuch's decision was only a dissent, even though 5 members of the court have either signed on to the opinion or expressed sympathy with it. Thus, Gundy was really not an originalist triumph, but instead, I think, a possible sign of originalist decisions to come. To my mind, actually, the most significant originalist developments in the past year fall into this category of indications of a vigorous originalist future. In addition to Gundy and the new circuit court judges, I want to mention 3 significant developments that suggest a potent originalist future. First, there's the emergence of Justice Gorsuch as a strong voice of libertarian originalism. Over the past years, Justice Gorsuch has written opinions in dissents or concurrences that see the original meaning as providing stronger protections for individual rights and stronger limits on government than the other justices do. These include his view on his view that the Fourth Amendment applies to cell phone location data, that patent rights cannot be revoked without an Article III court review, that the Double Jeopardy Clause does not have a dual sovereignty exception, and that the Due Process Clause places limits on vague civil and criminal laws. Justice Gorsuch has defended his views in a recent book entitled A Republic, If You Can Keep It. In saying that Gorsuch is a libertarian originalist, I don't mean to imply that he reads his political views into the Constitution. Instead, I mean that he understands the Constitution's original meaning to provide strong protections for individual rights and significant restrictions on the government. A second important development is the emergence of a significant debate between 2 of the most committed originalists on the court, Justices Thomas and Gorsuch. While Justice Thomas and Scalia occasionally disagreed about the original meaning, the debates between Thomas and Gorsuch seem far more frequent, excuse me. When Gorsuch was first appointed to the court, he and Thomas voted identically for quite a while. It almost seemed inappropriate, but not anymore. In case after case, in Carpenter, in Gamble, in DeMaya, in all states, Gorsuch has taken the individual rights view, while Thomas has taken the government view. While this disagreement might seem like a problem for originalism, I don't agree. Although the disagreements about the original meaning have some costs, they also have some benefits. Disagreeing in an open judicial debate about the original meaning, paradoxically, I think, lends credibility to originalism. It suggests that originalists will not paper over their disagreements for a false unity, but instead will follow the originalist evidence wherever it leads them. It also suggests that originalists recognize that the originalist evidence can be conflicting, but that originalists should still follow the stronger view of the original meaning. In the long run, such disagreements, I think, lead to a stronger originalism, as the weaker arguments lose out to the stronger ones, and the justices publicly affirm their commitment to originalism. The third important development is the ongoing attempt to rethink the relationship between originalism and precedent. If one defined precedent broadly and followed it consistently, there might be little room for originalism as constitutional law. It's thus understandable that in the Supreme Court and in the circuit courts, originalists have been thinking about how to develop a significant place for originalism within the sea of non-originalist precedents. And the way they do this, at least in part, is by limiting the scope of non-originalist precedents. At the Supreme Court, Justices Thomas and Gorsuch stated in Garza versus Idaho, if there is little available evidence suggesting that certain precedents are correct as an original matter, the court should tread carefully before extending our precedents in this area. This approach is even being employed at the circuit court level, where circuit court judges have begun to use Justice Kavanaugh's language from his D.C. Circuit free enterprise dissent. There, Kavanaugh argued that the circuit court should resolve questions about the scope of Supreme Court precedents in light of and in the direction of the constitutional text and constitutional history. Similar approaches have occurred in several cases, including the opinion by Fifth Circuit Judge Don Willett in a case about the removability of the administrator of the Federal Housing Finance Agency. Most recently, the approach was adopted only 10 days ago by newly appointed Ninth Circuit Judge Patrick Bumate. Judge Bumate, who's going to be attending the conference, dissented from the denial of a rehearing en banc, in part on the grounds that the scope of non-originalist Supreme Court precedent concerning the Eighth Amendment should be considered in light of the original meaning. The large number of originalist circuit court judges makes this rethinking of the scope of precedent even more significant. Finding a place for originalism in the lower courts may allow circuit court judges to identify originalist cases, permitting those cases to be teed up for the originalists on the Supreme Court. Finally, I should not leave this subject without mentioning the use of originalism during the Trump impeachment. As with the impeachment of President Clinton 2 decades ago, both sides of the Trump impeachment used originalist arguments. But while I think the originalist arguments during the Clinton impeachment might have been the most important originalist event at that time, I don't think the originalist arguments during the Trump impeachment are the most important originalist event today. Other originalist developments are more important, which is not surprising, I think, because originalism has become a much bigger part of our legal world. Okay, well, Putting together a conference of this sort involves a great deal of work, so I would like to thank various people who put in the work and really deserve to be mentioned. And first and foremost, I want to thank Mike Ramsey. Mike and I co-plan the conference every year, and I'm extremely grateful for his help. I also want to thank Steve Smith for his help in selecting the papers and commentators. Thanks also go to Dean Stephen Ferrulo for his support for both the conference and the center. And in addition, I want to thank Stacy Groff, who's helped to organize the conference in recent years. And finally, I want to thank Rick Stack and the Hugh and Hazel Darling Foundation for their generous support. Their grant to the center has made possible the continuation of the conference, as well as a host of other activities that the center runs. Let me now say a few words about administrative matters concerning the conference. The papers will work as follows. First, the paper presenter will have approximately 10 minutes to summarize their paper. The commentator will then have approximately 10 minutes to give their comments, and then the presenter will have 2 to 3 minutes to respond. We'll then open it for discussions with a queue kept by the moderator.